Ted Frank, founded and ran the Center for Class Action Fairness beginning in 2009. He is now a senior attorney at the CEI version of the Center for Class Action Fairness. They merged in 2015. At the Center for Class Action Fairness, Ted Frank has won several landmark appeals, tens of millions of dollars for consumers and other plaintiffs, really doing what many have described as God's work, certainly essential work in correcting incentives of the class action business model. He's been a great friend of the New Jersey Civil Justice Institute, appeared at several events and participated in panels on a variety of topics. We really appreciate him joining us today to discuss his latest success in that general effort, which, as you all know, was the great victory in throwing out the settlement in the Subway sandwich class action litigation. So with that, I'm going to turn this over to Ted to give us a little bit of background on the Subway sandwich settlement and how he came to be involved in it. Ted?
Thank you, Alita, and thank you to the New Jersey Civil Justice Institute for setting this up. I'll try to keep this short because I think the interesting part is going to be the questions. Subway, of course, markets itself with their foot-long sandwiches and 6-inch long sandwiches. And a few years back, there was an Australian teenager who picked up his Subway sandwich in Australia, photographed it juxtaposed with a ruler showing that the sandwich was only 11 inches long, and he had a cute Facebook photo that started mildly going viral. Australia's social media manager for Subway then promptly stepped in it and issued a statement explaining that Australia was on the metric system and foot-long was just sort of a descriptive thing without actually being a foot long. And that made everything really take off because it seemed like Subway was, quote-unquote, trying to rip off its customers. And it really went viral. People started duplicating the experiment and finding the occasional sandwich in the United States that was shorter than 12 inches. But some people were getting bread that was shorter than the foot long. Subway instantaneously responded to the market pressure and said, gosh, we're really sorry about this. As you know, we bake the bread and bread doesn't bake evenly, but we're going to take additional steps of quality control to make sure that everybody gets a sandwich that's a foot long. But as you know, whenever there's a big major news story like this, the lawyers immediately follow. And there was a race to the courthouse with lawyers even telling reporters that based on all the publicity, they ran to the courthouse and filed class action suits alleging vast damages to the universe of Subway sandwich purchasers. Unfortunately for them, they didn't have a very good theory of the case. And as it turns out, Subway distributes to its franchisees uniform loaves or sticks of dough that are then baked at a uniform weight. And, sometimes the stick of dough comes out long and sometimes it comes out short and squat, but the bread is the bread and the underlying amount of food is the same no matter the shape of the bread. And since the meat, the cheese is also standardized, and since customers decide for themselves how much they want in the way of vegetables and condiments, nobody was getting shorted any food. Maybe somebody was losing a gram of mayonnaise here or a shred of lettuce there. But every consumer got to dictate the contents of their sandwiches. Every consumer could say, I don't like that loaf of bread because of the way it's shaped, and I want a differently shaped loaf of bread. So it was hard to say that any consumers were injured, and even the class representatives themselves said that it would make a difference to whether they purchased a Subway sandwich. So they had no damages class action. At this point, the right thing to do is to slink away in embarrassment that you don't have a case and there's nothing to do, looking to maximize their return. turned the B3 class action for damages into a B2 class action for injunctive relief, and quickly negotiated with very little litigation a settlement, and the settlement was Subway would agree to do for another 4 years what they had already said they were going to do, which was create quality control measures about the shape of their bread, and the lawyers would get money, and the class, of course, would get nothing. The class representatives would get the token amount. That was publicized and submitted to the court for approval, and this is where we came in. We're looking for ways to, at the Center for Class Action Fairness, to stop abusive class action settlements where only the lawyers benefit, the consumers get nothing, or where the lawyers are just getting a disproportionate share of the class action settlement value, be it by creating the illusion of relief or the illusion of an appropriate fee request. And here it was a question of the illusion of relief. The injunction did absolutely nothing for consumers. It was Subway agreeing to continue practices they were already doing. And the class action added nothing other than obtaining fees for the attorneys. And, you know, when we're looking for cases, and we have dozens and dozens of opportunities all the time, and which cases do we want to take? And this was a nice, perfect confluence of why we would want to take a case. It was a very clear-cut settlement where the consumers were getting nothing and the lawyers were getting everything. And we wanted to litigate that particular issue and litigate the issue of the illusory injunction. It was in a great jurisdiction, since it was in the Eastern District of Wisconsin. That meant that any appeal would go to the Seventh Circuit, and the Seventh Circuit has been very friendly to our idea that attorneys shouldn't abuse the class action system for their own benefit. And then, of course, because of the nationwide publicity of the Subway Footlong lawsuit and the underlying quote-unquote scandal, we thought it would be a case where if we could accomplish what we were accomplishing, it would generate some publicity for our mission and what we do, and make it a stronger precedent than if it was just a strike suit over a Walgreens merger, which got some publicity but not a lot of publicity. But this with essentially identical structuring, where the class members get nothing and the attorneys get the fees, then try to say that it's okay because the consumers didn't have a cause of action anyway, is certainly a problem of rent-seeking, and one we're hoping to stop, and a case that would get nationwide publicity on that issue is effectively a stronger precedent than one that just sort of disappears beneath the waves after a day or two of legal press coverage.
Ted, I have just an initial question. I'm very proud to say that it's my understanding that New Jersey was the site of the first rush to the courthouse on this claim. How did it wind up in the Seventh Circuit?
There was an MDL, and everything got consolidated in the Eastern District of Wisconsin. So there were 7 or 8 suits that were consolidated. Whether there were state court suits also that somehow escaped Class Action Fairness Act removal, I'm not aware. Mm-hmm. But my understanding is that the New Jersey case got transferred by the MDL. Okay. The Judicial Panel for Multi-District Litigation. The district court wasn't having any of our objections. Went ahead and approved the settlements and approved the attorney fee award. And some plaintiffs' lawyers' sites, not quite understanding what they were about to step into, sort of mocked us for the fact that we lost at the district court level. But, you know, we were sort of thrown into the briar patch. We were very happy to take this to the Seventh Circuit. And we thought any panel we would get there would recognize this as similar to Walgreens, as similar to a case we weren't involved in, but a decision written by Judge Easterbrook called Aqueduct. But we had a very straightforward appeal that the only benefit to the class here, quote unquote, was the injunctive relief, but they presented absolutely no evidence that the injunction was doing anything that Subway wasn't already doing. And everything else was attorney's fees. And, they had a quack providing an expert report, and the expert report assumed that before the settlement, every single Subway sandwich was short, and after the settlement, every Subway sandwich wasn't short, and that was worth a certain amount to class members. And if you multiplied the total number of sales to the percentage that was worth to class members, the settlement was worth millions of dollars a year. And it was pretty funny because in addition to all these utterly bogus and invented premises, the only real number there was the total amount of sales, which was under seal. When the expert actually did the arithmetic, he multiplied wrong, and then multiplied wrong in a quote-unquote corrected version. And what he said was worth $5 or $6 million. If he actually did the multiplication, was only worth a few $100,000. But regardless, it was a plainly bogus set of assumptions, and they abandoned the expert report on appeal and didn't try to base their victory on that. We argued it in the Seventh Circuit a year ago tomorrow, and we had a nice panel that included Judge Sykes, who immediately recognized our theory of the case and recognized how this was exactly like the Walgreens settlement, took the lawyers to task, and a couple of weeks ago, 50 weeks after oral argument, came out with a very nice decision adopting our theory of the case, recognizing that a settlement like this couldn't be approved in the Seventh Circuit, and calling the suit a racket, which is a line from the Walgreens case also. That leads us to this phone call today. It's a good precedent to have that class action attorneys can't have a valueless injunction and then collect attorney's fees on it. It's one we hope to apply to other circuits that are perfectly happy to sign off on settlements where class members get nothing from an injunction or get nothing from the underlying settlements, but large fees are awarded to the attorneys. And while the fees here are only $500,000, in our Duracell case, where the injunction applied only to a product that Duracell had discontinued, or in our motor fuel temperature case currently pending with a petition for en banc rehearing in the 10th Circuit, where the injunction would actually make class members worse off economically, and the panel acknowledged that that was a possibility, the fees were in the tens of millions of dollars. The Seventh Circuit did the right thing here, but courts are not consistent about doing this, and we have a long way to go on these issues. I look forward to your questions from Alita and from you, and happy to talk about this more.
I believe I read a news clip within several days after the initial news of your victory at the Seventh Circuit. I had read, I believe I did, that the plaintiffs' attorneys were going to appeal that decision. If or if not that's the case, could you update us on that? Because I'm reasonably certain that's what I read.
I don't know if they're going to appeal. They can ask for en banc review tomorrow.
Right.
The 2-week deadline.
Okay.
I don't think that will happen. There are only 7 judges on the Seventh Circuit right now, with Posner's retirement last week.
Right.
And this was a 3-0 decision, so you would have to get all 4 others
to run the table,
Easterbrook and Wood to agree to rehear it. So that probably isn't going to happen. Will they take it to the Supreme Court? Please take this to the Supreme Court. I'll even file
another Briar Patch situation. Yeah.
I'll file a responsive petition saying, please grant certiorari. If you're ever going to take a question of a frivolous injunction and class action lawyers getting paid for that to the Supreme Court, boy, I couldn't imagine a better set of facts than the Subway Footlong case.
Yeah.
What I did see them do is they filed papers in the district court saying the settlement is now terminated, and there are all sorts of secret facts that the appellate court didn't know about, and had they known about them, they would have come to a completely different result. And so we look forward to litigating those secret facts.
Okay.
And this was a little mysterious to me. As I read the opinion, the case is over. They told the district court it should be thrown out. There is no claim there. And the argument is, well, we're going to litigate this with different facts. That would seem to violate the doctrine of the law of the case. But I'm just a class action guy. Maybe there's some secret litigation formula there that lets them go forward anyway. But beyond the law of the case, I think it also contravenes the first law of holes, which is if you're in a hole, stop digging.
Right.
And it doesn't seem to be a wise move on their part to not just slink away at this point, but
right.
We'll see what happens.
I have a question about that slinking away. You mentioned that earlier in your discussion. Do the plaintiff's attorneys ever slink away, and do they ever have an incentive to slink away when it turns out that what they raced to the courthouse doors with didn't really have much in the way of merit?
I mean, it's interesting because what I often see from defense attorneys is we have to be able to settle these things. If we don't settle these things, they'll put us through millions of dollars of litigation. And we heard that in Walgreens. We heard that in Pampers, which was another $0 settlement where everything went to the attorneys. And in both cases, the underlying case was totally meritless. We also saw it in L'Oreal. We got that argument and the $0 settlement, and the court threw it out. And every time you actually have just a meritless lawsuit where the court says we are throwing out this settlement and not just please rethink about this settlement, and the court says no, we are throwing out this settlement. Every single time that happens, at least until now, the plaintiff's attorneys say we're not throwing bad money after good, and we don't have a case here. We're not going to redo a settlement where the class gets some money. We're just going to walk away. And that happened at Walgreens, and that happened again in Pampers, where Procter & Gamble put up $2.7 million on this frivolous theory that their diapers had improper chemicals that caused diaper rash, rather than just diaper rash happening. After the defendants fighting us tooth and nail, we end up saving them quite a bit of money, and not that we ever get a thank you card about it, but I think it's important to realize that if you can't settle these cases for $0 for the class and lots of money for the attorneys, and you actually have to share the proceeds of the extortionate settlement with the class, there's no longer a business model where that's profitable for the attorneys versus actually going after defendants for things that violate the law one way or the other, and then we can argue whether the laws are too broad or not, but at least they aren't completely frivolous like the Subway case or the Pampers case or the Walgreens case. And I think one needs to look at that ex ante decision of whether to bring the lawsuit in the first place versus just the ex post decision to settle. And I think I would like to think that we're getting fewer of these suits, and to the extent that there is any data of that, our Walgreens suit challenged the category of merger strike suits, and when there was a merger and acquisition that had to get shareholder approval, something like 97% of them in 2015 faced lawsuits. And it's not because 97% of boards of directors were breaching their fiduciary duty or failing to disclose every last jot and tittle that they needed to do to comply with Section 14 of the securities laws and the Williams Act. It was these were really good opportunities for extortionate litigation. And after Sean Griffith's win in Trulia and after our win in Walgreens, it wasn't that now these suits are getting litigated and forcing defendants to pay millions of dollars in discovery and litigation costs. It's that these suits declined 30%, and the only reason they didn't decline more is that they're looking, they're playing whack-a-mole and looking for jurisdictions that might ignore Trulia and might ignore Walgreens. And we'll see what the next iteration of that battle is. But at the moment, the number of those suits has absolutely declined, and I think that's a good sign.
So another question along those lines. The subway case seems to be a situation where there's really widespread recognition that this was a meritless case, and arguably that's why it got the attention that it did. So why did Ted Frank have to show up in order for this to get thrown out?
The plaintiffs perhaps offered a settlement structure that didn't cost Subway anything, and the defendant was being rational. They don't care about the larger implications to the system. They care about minimizing their attorney's fees and the litigation expense and getting an uncertainty off their books before the auditors complain about the uncertainty. And, some firms are just more inclined to litigate these things than others. State Forum is happy to take a bogus class action suit to the Illinois Supreme Court, even when there's billions of dollars of judgments on it. Other corporations and defense counsel are very quick to roll over and view their job as settling these things. And, there are negative externalities there, and I'm happy to try to create positive externalities with what we litigate, but it's going to vary from defendant to defendant on who fights these and how hard they fight them.
So, are you saying that it's built into the business model that we need Ted Frank and more Ted Franks in order to sort of whack this down, or do we just need sort of more state farms and more people who are willing to put up a fight?
I mean, I would love to see more defense firms fight these things harder. Sometimes the judges aren't there to let that happen, and you will need an objector to beat up the settlement. We can certainly use more Ted Franks, and at this point, it's not just Ted Frank. We have 6 attorneys at the Competitive Enterprise Institute who are spending the majority of their time on this. Some of them are part-time, but if we had more resources, we could bring more of these objections. There's some really unfortunate cases out there, and we see them, and we have a theory of the objection, and we don't have the resources. We have 11 appeals pending. We'd be happy to have twice as many appeals pending, but we would need twice as many attorneys. And we're doing this on a shoestring budget. One of the nice things about it is we can do a lot with very thin staffing, and we can make the money we get go a long way. We've, had hundreds of millions of dollars of impact on attorney fees, not directly, and then, the precedents we create are surely affecting hundreds of millions more. And we're doing that spending less than $1 million a year. Well under $1 million a year. So there's a lot more leverage to be had. There's a lot more we could be doing. There's a lot more others could be doing. And, eventually these things need to get to the Supreme Court, and those circuit splits are happening. And we'll probably have 3 cert petitions this term, and eventually one of them is going to get granted. And I think, a lot of this comes down to the 2 competing models of class actions. One is the class action as a substantive device for attorneys to act as private attorneys general and go out and do good for society, defined as whatever that particular class counsel thinks is good, versus whether the class action's a procedural joinder device to aggregate claims that might not otherwise be able to be litigated for efficiency purposes. but at the same time, the attorneys still have duties to their clients and need to be acting as attorneys. And while that seems to be controversial in academia, we see a prominent Vanderbilt law professor argue for the private attorney general model, even arguing that attorneys should get 100 cents on the dollar of all settlement benefit to encourage more class actions. And controversial in the lower courts. We heard from the 6th and the 10th Circuit that it's okay for attorneys to structure the settlements so that they get paid and their clients don't, because, gosh, class actions are a good thing. We want to encourage attorneys to bring them. But the Supreme Court, even as they split 5-4 on a variety of issues, is pretty close to unanimous on this question, and that is attorneys have duties to their clients, and the class action is a procedural device, not a substantive device, and it doesn't create new substantive rights. And if we can get one of these cases in front of the Supreme Court, I'm confident we'll win it 7-2-8-1-9-0. I don't think we're taking close cases up there either. So it'll be interesting how this proceeds over the next few years. But we're confident that the arc of history is bending our way.
What do you think of the competing? I mean, there is a sort of a competing view on this, that illusory injunctions are just a valuable mechanism that allow, poor and beleaguered defendants to get out of meritless stuff for cheap.
If you look at the individual case and not the negative externalities and not the long-term effects of incentivizing attorneys to continue to sue you over other meritless things, there's something to that. And there's a series of principal agent problems where your outside defense counsel doesn't particularly mind if the corporation keeps getting sued, and because that's more business for them. They don't necessarily want to get rid of the class actions, and State Farm took a big risk in fighting the class action it fought. If the Illinois Supreme Court had gone the other way and they couldn't get United States Supreme Court review, they're out a few $1 billion. And that's a lot of egg on a general counsel's face, and not all general counsels are willing to take that risk, especially when the benefits are going to accrue years down the line to this company and to other companies that the general counsel has nothing to do with. The safer thing to do, the risk-averse thing to do, is to agree to settle, even if it's not in the long-term best interest of the corporation.
On the two competing models that you talked about, with the, whether this is a substantive device for private attorney general regulation or a procedural joinder advice, you had a piece in the Wall Street Journal this morning on the CFPB regulation on arbitration. You want to branch out a little bit and address that as a sort of what sort of fills in on that other side of the competing model?
Well, are you talking about the question of deterrence? Are you talking about consumer choice on these things? What do you want me to address?
Well, actually, let's start with the deterrence question, because that seems to be sort of
sure.
Yeah.
So this is something I've written about in a recent law review article of Aaron Shelley, and that is, even if you believe in the deterrence model, the current system is doing deterrence very, very poorly, because the incentives are for lawyers to bring these meritless cases and then get paid for them, and that's the opposite of deterrence, because you're punishing corporations for being deep pockets rather than for doing something wrong, which in turn reduces the marginal cost to corporations for doing something wrong, because they're going to get sued anyway. And while they might face larger penalties for doing something wrong, they're smaller than what they could be because the marginal expense versus not doing anything wrong and get the suit anyway reduces it. So if you really care about deterrence, you want to get rid of these bad settlements. You want to get rid of these bad class actions, and you need to recognize that the system is incentivizing attorneys to bring them because when courts are not very well situated to determine the value of injunctions, and when they throw up their hands and say, well, there's an injunction here, and that might be a potential benefit to the class, and we're just going to sign off on it, then you get cases like the motor fuel case, where there must have been $100 million spent on lawyers in an MPO with over, I think, 4,700 docket entries and counting over what's been 8 or 9 years now, litigating over whether it's consumer fraud to sell gasoline by the gallon because, as you know, having learned a little bit of physics in third grade, liquid expands with temperature. Therefore, on a warm day, a gallon of gasoline will have slightly fewer molecules than on a cold day. And, you know, California spends a lot of money studying this, deciding whether they should change the regulatory system and require temperature adjustment at the pump when gasoline is sold volumetrically by the gallon. And what they learned was the effect on consumers when divided by the number of drivers in the state worked out to 1 cent per driver per year, whereas the cost of changing the pumps over to do that would raise the price of gasoline much more than that. So even aside from the fact that probably what they spent on that study outweighed the total informational loss to consumers of a penny per consumer per year, it just wasn't worth doing, and that's why all 50 states continue to permit gasoline to be sold by the gallon without any temperature adjustment. The lawyers litigated this against every single gasoline vendor. Some of them fought and won, and others of them took the subway approach and said, here's some money to stop bothering us. And those settlements took the form of money for the attorneys, $0 for the class, and a slush fund for the lawyers to lobby for changes to the regulatory system that probably is already optimally designed to benefit consumers, but will be worse if it's changed. And the district court was okay with that, and the 10th Circuit in the 3-0 decision was okay with that. And that's pure rent seeking. That's pure social cost, and that's not a good thing. And if the incentive is to just change policy, regardless of whether that policy is good, and judges aren't well situated to be making those regulatory decisions and permitting the litigation by regulation, you're going to get some bad results. And that's not good for deterrence if you care about deterrence, even if you believe in the private attorney general model.
Now to sort of the other half of that, the arbitration side as a means of compensating individuals. The argument, the sort of the public policy argument against that approach is the absence of the deterrent effect.
And it's an interesting question. It's I look for cases where class action attorneys have accomplished something that regulators weren't going to do anyway or couldn't do anyway. And it's always really questionable stuff. You have the Volkswagen case, and the class action attorneys jumped on that, got $175 million for themselves, but the only thing the class got was the refunds that the FTC and the state attorneys generals would have gotten for them anyway. And if you look at the Volkswagen plea agreement where they pled guilty and paid a fine, it said that they got a credit for their fine, dollar for dollar, for every dollar that they contributed to the class action settlement. So actually the class action settlement cost Volkswagen nothing. It was because it was money they would have had to pay the government anyway. And so the only thing that class action actually accomplished was to take money that could have gone to car owners and instead give it to very wealthy attorneys who make $1,000, $2,000 an hour off of that settlement. it's rational for consumers to say, well, we have this class action system. The class action system isn't going to actually do anything for me. Europe doesn't have class actions. They're not riddled with fraudulent financial transactions. I'm going to agree to pre-commit to alternative dispute resolution, such as arbitration. And in return, because I've committed to that, my vendor knows that they will not have these litigation expenses from class actions, or at least they will be lower as they litigate to defend the right to arbitrate. And in a competitive market, those benefits will flow to me, the consumer, and I'll get lower prices or better cash back on my credit card or toasters with my checking account or whatever. I think we know that consumers prefer that, because if consumers really cared about the ability to bring a class action and win millions of dollars for wealthy attorneys without accomplishing very much for the class, you would see advertisements. Hey, the bank across the street has an arbitration clause, but we don't. Come bank with us. And some consumers would pick the lower prices, and some consumers would pick the bank that permits the class actions, and they would be happy. And banks don't even compete on that. Even the banks that don't have arbitration clauses don't advertise that they don't have arbitration clauses. Now, Southwest happily runs multi-million-dollar advertising campaigns saying they don't have baggage fees, and there's cell phone companies that advertise about the flexibility of their contract provisions versus the contract cell phone contracts of other major cell phone providers. But you don't see these sorts of advertisements in the financial field, and that's because consumers prefer to compete on cost and benefits. You know, there's nothing stopping the lawyer lobbying groups, instead of lobbying Congress, to be lobbying consumers. Hey, pick this bank. It permits you to sue for class actions. They know that would be ineffective, and it's because they know that they can't compete in the free market that they're seeking regulation that will preclude that consumer choice and permit more class actions.
It's actually a really interesting idea. Even if you expect that consumers broadly embrace the idea of the class action model as a deterrent mechanism, you could even sort of imagine a world where you would see that sort of advertising and competition as a sort of, you can count on us that we will not be ripping you off because we so openly will subject ourselves to the class action model, and see it's because of that we aren't going to be. But even that, you don't see that as a sort of as an appealing line.
You know, it's very easy to say that Acme Bank is trying to rip you off. They force an arbitration clause on
right.
it. But here at Zenith Bank, we don't do that.